Well, good afternoon and welcome to this week's webinar presented by Beresford Booth PLLC. My name is Per Oscarsson. I'm a member of the Estate Planning and Probate Group here at the firm. Joining me today is Sarah Smith, also of our Estate Planning and Probate Group. Our topic today is Healthcare Directives, also known as Living Wills, and Mental Health Advance Directives. So we'll start. I'm just going to turn it over to Sarah to talk about Healthcare Directives.
So healthcare directives are sometimes called living wills. I can't tell you why, since they have little to do with living and nothing to do with your last will and testament, just proof that attorneys should stick in our lane and not move into marketing. But healthcare directives have to do with the discussion of what happens regarding end-of-life care. Now, this is not a post, which is a physician orders for life-sustaining treatment, that green sheet that you may have created with your physician that they've told you to keep on the refrigerator or something of that nature. That document has to do with life-sustaining treatment, meant to be easily seen and understood by emergency medical personnel. And that really has to do with medical and treatment decisions, and that's completed with your physician, and in fact needs to be signed by your physician. That is a separate document that if you have these kinds of healthcare concerns, perhaps you're elderly or have ongoing severe healthcare issues, that's a good discussion to have with your physician. But a healthcare directive, on the other hand, does not apply for any of those sort of life-saving techniques, resuscitation and things that would help you to survive. The healthcare directive come into play when the withholding or the withdrawal of life-sustaining treatment really would come into play if you're in a terminal or a permanently unconscious state, and it would only be done to permit that individual to die naturally. To put another way, what we're really talking about is prolonging the process of dying. So your healthcare directive, if you choose to execute one, will talk about the cessation of those kinds of life-sustaining treatment in the event that you are in a terminal or a permanently unconscious state. So sometimes people get a little nervous about this. What if I'm in a coma for a week? Are they just going to pull the plug and kill me? No. This document is defined by the codes pretty specifically. You are found to be in a terminal state if you are of an incurable and irreversible condition caused by injury, disease, or illness that would, within reasonable medical judgment, cause death within a reasonable period of time in accordance with accepted medical standards, and where the application of this life-sustaining treatment would only serve to prolong the process of dying, which in English means it's an incurable and irreversible condition where they don't expect you to live. On the other hand, a permanent unconscious decision is defined as an incurable and irreversible condition in which the individual is medically assessed within reasonable medical judgment as having no reasonable probability of recovery from an irreversible coma or a persistent vegetative state. So again, we're looking at a situation where, it's not that you've been unconscious for 24 hours and we're going to wait and see what happens, or a week and we'll wait and see. It is where you have been evaluated by clinicians who have said, there's really no reasonable hope of recovery. This appears to be permanent and irreversible. So what we're doing with this is essentially trying to do two things. One is to make your wishes known. If you are in that terminal condition or that permanent unconscious condition, do you wish to have that life-sustaining treatment continued or not, and allow nature to take its course and allow you to die naturally, so that your wishes are heard and respected? In addition, in my opinion, what you're also doing is you're letting your family know what those goals and those wishes are, so that they don't have to bear the responsibility of making that decision for you. So I'll be honest, of all of the things that we often do as part of estate planning. This is the one that is perhaps most likely to make people a bit uncomfortable. But it's also a deeply important one for those reasons. Now, there's not a single form that does this. Different practitioners have slightly different documents. Some of them, such as the ones that we use here, will include additional options, essentially, for us to discuss, which would include, in that situation, there are 4 things: artificial respiratory support, artificial nutritional support, artificial hydration, and or the use of pain medication to alleviate pain. And you can also discuss whether you would like to receive or not receive any of these options, which wouldn't really serve the purpose of trying to heal, although it might make you live longer, right? Depending on the circumstance, you'll certainly live longer with water than without. But these sorts of things are really meant to address the issue of comfort and trying to maintain your comfort during that period of time. A lot of people say yes, a lot of people say no. Most people pick some combination thereof. It's really just a personal choice. There's no right or wrong answer. And sometimes people will ask, well, you know, we have a durable power of attorney for healthcare decisions. This is something we've talked about in prior webinars, so you may have seen us discuss this previously. But if we've given this individual or individuals the authority to make all of my medical decisions, what is this for? Well, 2 things. Again, we're going back to making sure that your loved ones or your agents know what you would want in that situation so that they're not having to make their best judgment and have that responsibility. But also, too, you can choose whether or not you want that agent to have the authority under your healthcare power of attorney to have the authority to override this healthcare directive or not. In my experience, typically they are written in such a way that your agent has that authority to override this healthcare directive if they think that it's within your best wishes or what you would have wanted under those circumstances. But sometimes people say, you know what, I don't want them to even have the option. These are my wishes. This is my healthcare directive. And my agent will not have the authority to override those wishes and those directives. So that's just something to bear in mind regarding how these work together and perhaps how you might want to customize these decisions to suit your needs and your goals. Actually, speaking of how these things work together, I know Per was going to discuss mental health care directives and how that integrates into this healthcare planning system we develop.
So one of the things that I've thought about is you were talking about the fact that we have different options within our form. I think it's interesting. The state has a form in the statute, has a form of the healthcare directive, but the only option it provides is it's either yes to artificial nutrition and hydration or no to both. There's no yes to one and no to the other, and there are no other options provided. I think that's one of the things that's great about the statute. It says that you can include other instructions in that healthcare directive. Now, it would be things that would be related to that time of life and that care. And I think the fact that you can include pain medications, even if they may hasten the time of your death, I think it's quite useful. Some of the things that I think are common between the healthcare directive and the mental health advanced directive, they're both voluntary forms. You're not required to use either form. But as Sarah says, if you don't provide that kind of instruction, whether it's in that kind of a form or some other kind of a written document, just telling someone may not be enough for a medical provider, probably won't be enough for a medical provider to say, I'm going to go with that, I'm relying on that. Whereas if you've got something written, you've also not only provided information to your representative, whether that's someone who actually has an attorney, has a power of attorney in their favor that they can exercise, or if it may be a family member who may not have such a document and such an authority, but is close enough in relationship that a doctor or other medical provider may still rely on what you say. I think they both require witnesses. Both documents require witnesses. I find it interesting too that the mental health advance directive has more requirements for the witnesses than the healthcare directive. Generally, with the healthcare directive, it are things the witnesses, they cannot be related by blood or marriage. They can't be entitled to any portion of your estate if you were to pass away, regardless of how they might receive that. It can't be an attending physician. It can't be someone who's employed by either by the attending physician or by a medical facility where you are a patient. And finally, it's also the person who might serve as a witness cannot have a claim against the declarant, the person who is making that directive at the time that the directive is signed. One of the things that I find interesting about the witness requirement not being an attending physician or an employee of a medical facility is very often if you're going into a medical facility such as a hospital for a procedure, when you're being admitted, you'll be asked, or you're often asked, I don't know if it's still the case, but I've understood this to be the case, you'll be asked if you have a healthcare directive. And if you say no, they will offer you one. Now, I find that there are two potential problems with that. One, they cannot give you any legal advice in providing that. And there are options to the form. And I think my guess is that the form that most of those medical facilities provide is taken directly out of the statute. So it won't have the opportunity for some of those other things that if you decide to do a healthcare directive in advance, well in advance of its being needed, you have the time to think about those things and then make a decision, as opposed to the 15 minutes or 20 minutes or 30 minutes, whatever it is, that you are sitting there with an admitting officer to a medical facility. Number two, they would serve as witnesses. And although prior to your admission, you may not be a patient in that facility, as soon as that's signed and as soon as you're admitted, you are a patient in that facility. And now you've got witnesses who are now employees of the facility where you are a patient. So for those 30 minutes or whatever it is prior to you actually being admitted, I'm not so sure if that's sufficient to say that prohibition on the witnesses applies. Now, the difference with the mental health advance directive requirements on witnesses, a lot of those are the same. But there are also things like a person who already serves to make healthcare decisions for you, such as a healthcare attorney, in fact, cannot serve as a witness. It cannot be a healthcare provider or professional person who's directly involved in providing care to you at the time the directive is executed. One of the things about related by blood or marriage, and I find this one interesting, is that the witness to a mental health advance directive also cannot be in a dating relationship as defined by statute with the principal, the person who is signing the directive. That limitation does not appear for the healthcare directive.
No.
There's one of the differences between the healthcare directive and the mental health advance directive too is on who can do one. The healthcare directive is available to adults, specifically adults, defined as someone over the age of majority who is not an who is not an emancipated minor. For the mental health advance directive, it's available to adults, but it's also available to a child between the ages of 13 and 18, which is the age of majority, who can show that they have the ability to give informed consent to behavioral care. I can see the difference for that for a mental health advance directive, more so than being able to allow someone of that age to make a decision for healthcare directives, because that's an end of life thing. unfortunately, end of life could happen for them before they reach 18, but they don't have the ability or the authority to do it because they're probably not treated as having enough capability to understand a lot of those issues that would probably apply at end of life. Another thing that's different between the Healthcare Directive and the Mental Health Advance Directive is the Mental Health Advance Directive provided by statute is significantly longer and significantly more detailed than the Healthcare Directive. The statute does provide, and the form that's provided have 3 sections that are mandatory in order for the Mental Health Advance Directive to be valid. One is you have to identify when it's effective. That is it effective immediately? Is it only effective if you become incapacitated? Or does it apply only if certain behaviors or symptoms occur, then it's effective? Another difference is that they're only effective if you describe or define the duration of the directive, which could be an indefinite period of time, or it may be a specific limited period of time. And then also, different from the Healthcare Directive, you also have to identify in the Mental Health Advance Directive whether it is revocable by you only if you have capacity, or is it revocable by you even if you are incapacitated? Now, the rest of the form also provides things where you can describe what your preferences are for types of treatment, providers that you want to have. You could also identify providers that you do not want to have, or treatments you do not want to have. If you are to be admitted into a facility for mental health reasons, you can identify in the directive who is permitted to come visit you and who is to be kept out. That's very different from the Healthcare Directive, again, maybe because of the difference in when during your life the Mental Health Advance Directive might be used. You can identify the types of medications you're on. If you're already on medications or receiving treatment for mental health issues, but you have capacity and it's controlled by the treatment and controlled by medication or a combination, you can identify what you're being treated for, by whom you're being treated, and any medications you receive in connection with that care. You can also provide information about what kind of medications you have for other conditions you may have that are unrelated to mental health issues. There is the possibility of giving consent to being admitted for inpatient treatment in case a mental health crisis occurs. And you can identify whether or not that should happen. It limits it to 14 days at most, unless you do identify a shorter period of time. Or you can also say that you do not consent to being admitted to any kind of a facility. You can ask for alternative or provide for selection of alternative treatments prior to any treatment outside of some sort of a mental health facility. You can provide your wishes on choice of if electroconvulsive therapy is to be used or not to be used. And so, and then the other one is, within the document, you can also identify someone to serve as your attorney in fact for mental health issues. So the Mental Health Advanced Directive can also identify that you have other documents, such as a healthcare directive or living will. It may also identify that you have identified a healthcare attorney in fact under a different document, because the Mental Health Advanced Directive is intended to work either in combination with those or independently of them. Now, I think if it's independent, then it becomes important to make sure that they work together and that they don't conflict with each other, because that can cause issues. For example, with powers of attorney, typically when they are written, and let's just focus on the healthcare power of attorney, it typically says, I hereby revoke all prior healthcare attorney powers of attorney I may have granted. Well, if you're doing that, if you're granting the power of attorney for mental health issues in the Mental Health Advance Directive, you may want to be very, very careful that if the person who is to serve as your agent or your attorney in fact under the Mental Health Advance Directive is not the same person who you have appointed to serve as your general health care attorney in fact, you want to make sure that neither one of those documents has the effect of canceling or revoking the other. So coordination between those two is going to be important. Coordination with a healthcare directive is not as important because of the fact that they deal with different issues and different times of life. I think for right now, I think that probably covers what we wanted to cover about the fact that these are two different types of documents, both related to medical care, one being much more specific as to what type of medical care and when, that being the Mental Health Advance Directive. I do want to make it clear that they are voluntary. I think it is a good idea to at least consider them. And if you're interested in a Mental Health Advance Directive, I think it is important to have that conversation with your attorney, probably with family members as well, and maybe even with your medical providers, because as I said, the form itself is much more detailed than a healthcare directive or living will. And so there are a lot of things that can go into the healthcare directive that, in theory could go into a mental health advance directive that probably would not go into a healthcare directive. But again, you have the flexibility in the healthcare directive to include a lot of information there as well. That would not relate to mental health issues, but I think it's important to at least consider and expect that it's probably going to take you a little longer to think through the various issues that you can cover in a mental health advance directive, and not just sit down and figure, I'm just going to sign. Maybe initial a couple of places and sign, because that is probably not in your best interest. Sarah, did you see if we had any questions pop up?
I am not seeing any at this time.
Okay. Well, I think with that, we will say goodbye and hope that you will join our family law group. Lisa Doe of our family law group is going to be giving our webinar next week, and we'll be talking on the calculation of child support in family law cases. So with that, we thank you for joining us, and goodbye.